This comment brings up a good point about the financial disclosure requirement here in Colorado. So when you have a divorce or custody case, the statute requires that both parties disclose all of their financial information without the request of the other party. It's a mandatory disclosure that each party has to do automatically. Now, that doesn't mean that the parties always do it, although they should. If it comes out within 5 years after the divorce was finalized that one of the parties did not provide a complete disclosure, usually it's because there's an asset hidden. If there was a debt that was hidden, typically the other party doesn't want anything to do with it, and it's pretty easy for the court to confirm that that party who didn't disclose it is going to be responsible for it. But if there's an asset that the other party does feel like they are entitled to a portion of, if it's within that 5-year look back period, the court can reopen the case and address that asset. So, the trick I always get asked is, well, how am I ever going to know if they're hiding it? That's a fair and valid point, but the court does try to account for that. If you are in a divorce case and you feel that the other party is not complying with the mandatory disclosure requirements, there are documents you can file while the case is going on to compel those disclosures. And if you're 5 years out or less from your divorce and you find out that something wasn't disclosed, you also may have the possibility to reopen your case.